Whenever you have a merger, acquisition, a corporate restructuring, you should be sure that immigration considerations are on your due diligence checklist. And the reason why is because the foreign national workforce is mostly going to be affected. You may be losing some of your most valuable assets, your human resources, as a part of the merger, acquisition, or restructuring. A lot of employees may lose their status as a result of the restructuring. For example, anyone in L1 status may lose their status. An L1 is an international company transferee. It relies entirely on a corporate relationship between the U.S. entity and a subsidiary or an affiliate or a parent or branch of a foreign entity. If that corporate relationship is broken because of the restructuring, there's no more L1 eligibility and that person has no status to be here in the United States. An E1 or an E2 visa is for a foreign national from a treaty country, a country that signed a treaty that allows for this kind of visa, to work at companies that are owned at least 50% by nationals of that country. If the ownership of that U.S. entity now changes and 50% is not owned by nationals of that country, there's no more E1, E2 eligibility, and that person has no status to be working in the United States. So there's a lot of times when your most valuable employees may lose their status to be able to stay and work here as a result of the merger, acquisition, or restructuring. H-1B employees need amended filings if the FEIN of the resulting entity is different than the sponsoring entity. So it's important to just put it on the due diligence checklist, go through the roster of foreign nationals and see how everyone is affected, and then file whatever is needed to file to keep them here.